Okay, hello everyone, welcome to the tutorial session of the final examination LB231, the business organization. So we'll look through the first question here. So, enterprise is a private company with the registered capital of 1 million baht. Shares of enterprise are held by 5 shareholders, James, Spock, Uhura, Pike, Leonard as the proportion appeared. So, first thing to consider here, because this is private company, therefore all law apply after this is from Thai Civil and Commercial Code. And because of, we have the fact here that the AOA state that the board of directors consists of 5 directors. So, when we have more than 3 directors, section 1160 say that in director meeting, the meeting of the director, we have 3 persons as a quorum. So, the fact further state that the shareholder meeting appoint only 4 directors, James, Spock, Uhura, and Pike, and the board of directors agrees to appoint James to be the chairman. Okay, there's still nothing to consider here. James sent a notice calling the board meeting to all directors. Here, it is section 1162 where any director can call the board meeting at any time. And Spock is hospitalized, so we has his son, Sir, attending the meeting instead. The question is that here, can Spock really appoint someone, Sir, which is his son, to attending the meeting instead of him or not? The question to consider here is that can the board really appoint the proxy into the meeting? And the answer is no. Even though the law did not state clearly like whether the director can appoint someone to enter into the meeting on behalf of him or not, but it is based on the uh, quality of the director. When the shareholders choose someone as a director, the quality of that person is an essential element. Therefore, it is a task which is his personal task. It is his personal right and duty, therefore he cannot have someone to do it on behalf. So, we can see that the facts say that before the commencement of the meeting, chairman informed the meeting of Spock's situation and asked if anyone object the attendance of none of the director has any objection. This is not the matter because whether the other members of the board say yes or no, Spock here as a director cannot appoint someone to enter into the meeting on behalf of him. Firstly, the chairman proposed the board to appoint one more director to handle increasing workload. The question is that whether the board have power to appoint a new director or not, and the answer is technically yes according to section 1155, but only in case of the vacancy of the position, or in section 1159 where the members of the board is not sufficient, was vacant and not sufficient to constitute a quorum. In that case, the board can either appoint a director to constitute the quorum or call a meeting, call an EGM to appoint one more director, or the number that was left and need to constitute the meeting, or even when calling the EGM, the board may ask the shareholder to appoint the director in full number. James further explained that according to the AOA, the board shall consist of 5 directors. It is an option to elect one more director. James' explanation here is not correct because of AOA state that the board shall consist of 5 directors and it is the regulation of the company which is compulsory, not an option for the board to select whether they will have 5 or not. And also directors agree as this benefit the company. Eventually, the meeting anonymously appoint a new board member. The question is that can the board anonymously appoint a new board member in this case? Even though we can see that section 1155, the board can appoint one more director or more director in case of there's a vacancy in the position that is not in accordance with like normal leave, like some like the leave in section 1152 and 1153 count that. But in this case, we can see from the fact it say that it consists of 4 directors from the beginning. Therefore, it is not the case of vacancy and the board cannot appoint the director by this board meeting because the condition is not satisfied in section 1155. Next, the chairman informed the meeting that the appointed auditor passed away and it is necessary to appoint a replacement to audit the company financial statement. All the directors also agree, and the meeting finally appoints a new auditor. So, this as well, the meeting cannot appoint the new auditor because in case of the auditor pass away or the auditor leave the position, Section 1211 say that the board must call the extraordinary general meeting or the EGM to appoint that auditor. So, after the meeting, Leonard is informed that the new board member is appointed and he is not happy with the resolution, as Leonard wished to sit on the board. So, as you are Leonard, lawyer, please advise that if the resolution of the board of director meeting are in accordance with the law. So, there are two resolution of BOD here. The first one, appoint new director. And the second one, appoint the auditor. And because we already mentioned that the board have no power to appoint the director in this case because the condition according to section 1155 is not satisfied. So only thing that the board can do in case they want to appoint the new director in this case is to call an EGM by section 1172 and have the shareholders exercise power under section 1151 to appoint one more director. So in this case, the board have no power to do so. Therefore, it is unlawful. The resolution of the board of directors in this case is not in accordance with the law. And the next one, to appoint the auditor as well, it is compulsory by section 1211 as we already mentioned. That in case of the vacancy in the position of auditor, the board was obliged to call the EGM in order to appoint the new auditors. Therefore, it is not power of the board. It is not in accordance with the law as well. Then we have further question, how to revoke the resolutions, which mean the resolution of the board of directors. Even though section 1159 section 1195 provide the solution in case of the resolution of the general meeting is unlawful and give the power to the board or the shareholders to revoke. But the law did not provide any solution in case of there's the unlawful board resolution. Therefore, in fact, it may imply in this case that there is no way to revoke the board of director resolution. And then you might have a question, then how can the shareholders do so? I have to say that the law already provides the solution in section 1169. In case of the board did not exercise care or the board managed something wrongly, and it caused damage to the company can sue the board of directors. And in the case that the director did not sue the company because of, in fact, the director is someone who do the act on behalf of the company, they may not sue themselves, then we can apply section 1169 for derivative action, where one of the shareholder may sue the company, may sue the director on behalf of the company, but we cannot revoke the board resolution.